The only fundamental right that can be violated is perhaps Article 14, and that too, the limited part of Article 14, that the law is arbitrary. Is this law arbitrary? This doesn't appear to be so. The bill takes away 3A from the ordinance. To my mind, it's a perception, I may be wrong. To my mind, when 3A has been taken out of the ordinance and it is not there in the bill, the questions referred to the Constitution bench stands self-answered. Because if you read the order of the Supreme Court referring the matter to the Constitution bench, a copy of which I have got and I have read, my view is that the entire reference has been necessitated by the provision of 3A of the ordinance, which no longer exists. Therefore, it is the prerogative, the right of the members of the House to debate. The question of sub judice doesn't come. So far as overreaching or outreaching the order of the court, Supreme Court is concerned, very shortly put, the position in my perception is this. The state legislature makes laws for the states, Parliament makes laws for the union territories. For the National Capital Region of Delhi, which has a special status, the state legislature or the legislature of Delhi makes the laws on the state subjects, except 3. But as Mr. Jethmalani read out, by virtue of 239 3B, Parliament has a power to frame laws beyond these 3. And that is exactly what the bill is seeking to do. Therefore, there is no question of overreaching. And what has the Supreme Court repeatedly said? Paragraph 164, 2 conclusions. These are the 2 conclusions. May I read out these 2 conclusions? The legislative 164C, the Legislative Assembly of the NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries. In addition to entries in List 1, in addition to entries in the Union List, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD. This is the conclusion in paragraph 164C. Paragraph 164F, the executive power of the NCD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. So this is the conclusion of the Supreme Court. And therefore, now, what has the Supreme Court repeatedly held in the 2018 judgment and the 2023 judgment? Precisely this. And I'm very grateful for the fairness shown by the first speaker, Dr. Singhvi. If I'm not mistaken, what Dr. Singhvi said, the power of Parliament is not in dispute. He said it very fairly. The power of the legislative competence of Parliament is not in dispute. then why would this law be bad? This law would be bad if it violates the fundamental rights, number one. Number two, if it violates any other provision of the Constitution, and if it violates the basic structure of the Constitution. Right. In any case, Honorable Chairman, sir, I have come to the end of it. Violation of fundamental rights. The only fundamental right that can be violated is perhaps Article 14, and that too, the limited part of Article 14, that the law is arbitrary. Is this law arbitrary? This doesn't appear to be so. The law may not be to my liking. That does not make it arbitrary. Absolutely. Next, does it violate the basic feature of the Constitution? Sir, I have to say something about the basic feature.
Please.
There's a book by Mr. Andhar Arjuna,
Yes, yes.
the former Solicitor General, on the Keshavananda Bharti case.
Yes.
Having read the book, my view is that the doctrine of basic structure of the Constitution has a very debatable jurisprudential basis. I would not say anything more than this. I wouldn't say anything more. The doctrine of basic structure has a very debatable jurisprudential basis. In any case, Honorable Chairman, sir, what the bill provides is diluted form of what federalism, because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, asymmetrical form of federalism. And the third thing is, does it violate any other part of the Constitution? The Supreme Court mentioned about triple autonomy. What you have under the bill is a modified form of triple autonomy. The bureaucrat is responsible to a lieutenant governor, who is responsible to the Home Ministry, who is responsible to the House. You have a modified form. If you want a full-fledged federalism, which today is a basic feature, though I have my own perceptions there, you can go for an amendment, for a constitutional amendment, and make Delhi a full-fledged state. Now, the most important thing, Chairman Sir, is Article 239AA, starting from 1 to 7, is not under challenge before the Supreme Court. Challenge it. That is not under challenge. Therefore, in my respectful submission, my contention, the bill is perfectly legitimately valid. But I fully support Mr. Bikash Bhattacharya, who has been a very close associate of mine. What is permissible need not necessarily be right. In the House today, parliamentary democracy compels members to vote according to party dictates. Fine, I cannot quarrel with that. It's a small section of people to whom you appeal to their conscience. To me, the bill is correct, right. My conscience tells me to do something, I'll do it. But if somebody disagrees, his conscience must be left free. Thank you. I am honored. I'm privileged.